Welcome to the final workshop of our six-part Get It Done webinar series on estate planning. I'm John Mitchell, CEO of Ardenwood here in San Francisco, and with me once again is Rick Bailey, one of the most respected estate planners in the country. Thank you for joining us today. You know, we've come a long way over the last 6 months of working on this project, and our hope is that you're almost ready to bring your estate plan to your attorney to polish and finalize and get it done. Rick has helped countless Christian Scientists at every stage and income level to navigate estate planning with clarity and care. We're grateful for his support throughout these sessions. Today, Rick will wrap up the key points we've covered and talk about what happens after you pass. You should have received a recent document attached to the Zoom invite mailed to you about an hour before this webinar today. As always, Rick is happy to answer your questions. To protect your anonymity, once again, please post them using the Q&A button or icon at the bottom of your Zoom screen. I will read each one aloud without mentioning your name so that everyone can benefit from Rick's response. We'll have a little bit extra time today for your questions, so please don't hesitate. And with that, let's get started. Welcome, Rick.
Thanks, John. I appreciate it, the time, and I'm glad we're at session number 6, so we're there. Now we can start wrapping up. So as we go through, I'll go through this PowerPoint slide. More on this is just so we can all get on the same page a little bit. And with as we look at this, it really comes down to getting everything finalized so that you're ready to move forward on this plan. I was reading through some things yesterday, and a plan doesn't do anything unless it's actually implemented. And so all of your wants, desires, whatever for your plan, if it's not implemented, it doesn't happen. So let's start looking at this. As we go through, think about, what you need to do to finish things up. So when I look at completing the plan, it really is the 3 stages. What happens to you while you're living and healthy? What's going to happen to you if you become legally incapacitated? And what happens after you pass? And so all of this is designed to help you really take advantage of every step of this, making sure you're in control and your desires are happening. So while you're alive, you want to control your assets. You want to make sure that everything is organized now so that if something happens, whether you become incapacitated or pass, that the next people are ready to step in. So all of these documents are really designed to help you make sure your plan is in place for you. And everybody's plan is going to look different, because it's based off of your goals, your objectives, your family situation, your income, your assets, whatever it is. All of this is designed to do everything according to your desire. So the key message, here at the bottom, it's about getting the documents correct, making sure, and when it says funding, making sure the assets are where they're supposed to be. If you have beneficiary designations, they're correct. And that you always review and keep this up to date so that on an ongoing basis, everything happens according to your desires. Now, think about the documents, and I call these the foundational documents. You're going to either have a will or a trust. Now, with the will and the trust, a revocable living trust. If you're in a state like California, you want to have a revocable living trust because ending up in probate is going to be time intensive and it's going to be expensive. So not all states have, what I'll just say are horrible probate laws, but all probates open you up to the court. They open it up to the possibility of creditor claims and things that just make it messy. So if we can avoid going into probate, in most cases, we want to do that. It's all going to depend on your assets. And I've talked to a lot of people that I've told them, the way their assets are set up, because most of them are financial assets, they don't have a home. Therefore, you can avoid probate just with beneficiary designations. If you can, great. If probate's not going to be a big issue in the state that you're in and with your assets, then you can do have the same plan inside of a will that you can inside of a revocable living trust. Just understand, if it's a will, it's going to go through probate to pass those assets on. And I look at a pour over will. Even if you do a revocable living trust, you will have a pour over will. What that means is that will is designed, go find the assets that weren't put in the trust the right way and move them in. That's all that will is designed to do. So I tell most of my clients, that's oops. Oops, we forgot something. If we had really thought it through or knew about those assets, we would have put them in the trust, but didn't happen, or we have to clean it up after. The other one is we want to have an advance directive. That advance directive, and you'll see here in a minute, we'll talk about the powers of attorney. But the advance directive can be wrapped in with the power of attorney. That advance directive is going to tell everybody, here's how I want to be taken care of from a medical standpoint, from a health standpoint. What you want to have happen or don't want to have happen has to be in that advance directive. And you're going to give the people that you trust and that you want to have control to be able to make decisions for you the right way. The next thing is to have an asset list and instructions. I look at this, with my parents. If something happens or when it happens with my parents, they've lived in the same home for now 55 years. If I had to go look in every nook and cranny trying to find every asset, something's going to be missed. But my dad is great at keeping things orderly. And so everything is supposed to be in a filing cabinet or in one of his briefcases. And it's one over time. We've gone back through that with him, making sure that something's not missed, that we understand what there is and where it is. Now, you may not want to tell your kids, things right now, but make sure they know where to look. And the more orderly it is, the better that the process goes. And it every time somebody passes, it's there's emotional things, there's family things. The last thing we want to have is we've got to go hunt for assets at the same time, or look for bank accounts, being able to take over and make sure things are not falling through the cracks. So the more orderly you can keep it, the better. And having that list will take care of everything. Now, the last two things are having the financial power of attorney and also the healthcare power of attorney. Like I told you, the healthcare power of attorney and advance directive in a lot of cases are tied together. But a power of attorney, you are giving somebody the ability to take care of either your affairs, your assets, or your medical and health decisions. And so typically when that happens, and this goes back to agency law. So agency law says, I can give somebody the power to act for me. Now, what you'll find with these they're going to say durable power of attorneys. So under true agency law, if you can't make a decision, your agent can't make decisions for you. But under a durable power of attorney, that durable says, even though I may have lost legal mental capacity, my agent still has the ability to act for me. So one of those is for financial and property decisions. The other one is going to be for healthcare decisions. We need two, and we want those two because it makes sure that there isn't something missing in the process. Like I said, with the will and the revocable trust, the will names the executor, directs where the probate assets are going to go. If you have minor children, it's going to name the guardian for the minor children. And so if you have minor children, that's a must. Who's going to take care of the kids? And that will, nothing happens until death, and then the probate's open, and then we go through that public probate process. With a revocable living trust, if you think about it, we're doing the probate while you're alive. We're going to set up the trust with all of the provisions that you want. how things are supposed to be moved, just like we would have done with the will and the probate assets. But it tells us, here's how you want your affairs managed. The nice part of this is, if you get to the point you can't manage your own affairs, then your successor trustee steps up in that place for you. The assets are already where they belong. And so now your trustee has to go to the bank, change the signature card, those types of things, but they're ready to act for you, take care of you while you're alive or in that long-term care situation. But when you pass, we're not going through probate. They just manage the trust like you've told them to do, whether that's continue the trust for a set number of years, distribute everything out and close up the trust, or with some of my clients, we have trusts that will last forever. It's whatever you want it to do, but we want that to be a very, very smooth process. No matter what it is, the more orderly you are, the better the process will go. When I look at the word fiduciaries, and this is one where I don't think a lot of attorneys take the time with their clients to really think, who do you want to take care of you and your affairs? So if you think about the executor and the personal representative, that's very similar to the same role as the trustee. Who do you want to be in charge? And I see a lot of times, in fact, I met with a prospective client a few weeks ago, and they have 3 kids, and they're like, can't we just have all 3, be the trustees or for us, or all 3 be the executors on the pour over will? And I said, yeah, you can. Is that the right answer? And I asked them, it's 3 boys, and I said, do your 3 boys get along? And they laughed and they said, no, they don't get along. They like each other, they love each other, but they fight and bicker just like, boys. And I said, so what you're telling me is let's put them all in charge and they're not going to be able to make a decision for you or to take care of your things. And they said, well, that's probably not the right answer. And I said, who's the most organized out of those? And they named, was their youngest son. And I said, is he the right person to put as the first successor? And they said, actually, he is. And I said, who would be second? Who would be third? Let's name all 3 of them, but do them in order, because they don't get to, they're not choosing what to do. They're just following through on your directions the way you've laid it out. So put the people in charge that should be in charge. Under the financial power of attorney, there again, who do you want to take care of your things? You haven't passed away. This is to take care of your things, your property while you're alive. That might be paying your bills. That might be making sure that you're taking care of your home, you're in assisted living, whatever it is, that is taken care of because they're taking care of those assets on your behalf. The healthcare power of attorney or agent here, under the healthcare power of attorney, who do you want to be making, healthcare decisions for you? That might not be the same person that's the successor trustee or the agent under the durable power of attorney. So think about who knows your wishes, who will follow through on your wishes, and name the person that makes the most sense for you. And there again, update that on a regular basis so that we're not guessing, is this who you wanted? Because it's who you name, who's in the documents. That's the person that's going to step up into that role and make sure they're willing to do that. There again, if we have minor children, we want to have the guardians in place to take care of them. When we look at real estate, and I don't like the word funding, that's just happens to be the legal title. Think about this. If we're moving real estate into your trust, we have to retitle the ownership to the name of the trust. So real estate, bank accounts, brokerage accounts, business interests, all of those assets that you own need to be moved into the trust. They have to actually have the proper title of the trust. And when you title it, it's going to be the name of the trust and the date the trust was signed. Those are the big things that we're looking at. And if you go to the bank, they're going to want to see, the first and typically the first and last pages of the trust so that they know when it was put in effect and when it was signed. And so that's all important. If you look at your second job in getting your assets organized. It's coordinating your beneficiary designations. So IRAs, 401ks, life insurance, annuities. I just opened up a new bank account the other day for one of my businesses, and they asked, do I want to put a transfer on death? So that if I said yes, then when I pass away by contract, that beneficiary designation would go to whoever I named. I said, no, I don't want to have a beneficiary designation. I actually wanted to go into my trust, and I gave them all my trust information. The nice thing about having it go into my trust, number one is when I do my reviews, I review my trust. It's easier for me to review my trust and make sure it's up to date than always remembering, oh, I've got to go back and check every single beneficiary designation. I want to make sure my beneficiary designations are correct, but I've got to remember, is it going to my trust or is it going to one of my kids or all of my kids, however it's set up? So make sure that we have all of that coordinated. One of the other things we talked about is who gets what, when, and how. And the what, when, and how are important as you start thinking about your estate plan. It's not one, if you came in and you haven't thought through the what, when, and how, you would be coming to me and we're going to have that conversation, and you may not be ready for that conversation. So think about this. Are there people that you want to give specific gifts to? So as I go through, doesn't matter if it's the will or the trust, when we set this up, the first thing we look at are specific gifts. So let's say I have that, let's just say it's my business. I want to give my business to my son who's been working in the business with me. I can name that and it would say, upon my passing, pass my business interest to my son Tyson. That is a specific gift. Specific gifts get filled first. So think now that where I just went through a review with one of my clients. One of my clients had set it up so that they gave money to their grandkids. They gave money to their great grandkids. They were going to set up as a specific gift, a trust that was going to be funded to handle education. Well, it was all set up and they did this, years ago. Well, over time, they've been spending their estate down. And as we did this most recent review, they realized they were giving all of their money to their grandkids and great grandkids, either as educational benefits or outright gifts. And there wasn't going to be much left for their kids. And there again, there's no right or wrong to it, but they went back and had to look at the specific gifts and they said, well, you know what? We're going to do smaller amounts. We still want to give things to our kids, our grandkids, and our great grandkids, but we're going to cut those amounts in half. And they looked at the education, trust that they were going to set up and thought, you know what? We've helped our grandkids and great grandkids already on a lot of their education, and we've helped their parents. We're going to get rid of that and let that go into the residuary. So specific gifts go first. Then if we get to cash or general gifts, if you've stated a specific dollar amount, and I see this a lot of times, give it to one of my siblings. So I give it to my sister and say, I want $10,000 going to my sister. There again, it falls in line really like with a specific gift. Now it says, I'm going to go give that $10,000 to my sister, or I give $100,000 to my favorite charity, whatever it is, those get taken care of next. Now we go to box number 3, and that's the residual or the residue. That's everything else. And typically we say, now divide that up. So if I have 5 kids, it's going to say, I may say, divide it up equally so they each get 20%. Be careful there. So if you're giving specific gifts or you're giving specific cash gifts, those get taken care of first. So what you thought might be being split up among the kids or whoever in the residual, if you've used up, given it all away and there's nothing left in the residual accounts, well, there's nothing left to split. So there's no right or wrong to this. It's just making sure you've thought through, is this what you want to do? And I like instead of specific dollar gifts, maybe we divide it up in percentages. So a lot of times in retirement, you're spending down your estate. And now instead of saying, okay, $100,000 to charity, maybe we just go in and say 10% to charity, and the other 90% gets divided among the kids. So think through not only what it looks like now, but what it's going to look like in the future. And there again, just make it work the way you want it to work. We talked about in one of our sessions talking about special beneficiaries, those beneficiaries that need extra protection. So that might be with minor children. With minor children or young adults, they may not be ready to take on and receive a gift of a large amount of money. A lot of times, and I compare this to people that win the lottery. Most people that win the lottery, they're both broke within 3 years. And the reason they're broke, it's easy come, easy go. And if your minor children or young adults aren't ready to take on and manage a big lump sum gift coming through an inheritance, instead of taking that as the gift that it is, they look at that as free money, and it gets spent rather quickly. And I see that in too many estates. So think about this. Do we need to add more protection for them? Do we need to have a trust for them that is going to help them, instead of receiving a lump sum all at once? There's a trust that takes care of their health, their education, their living expenses, helps them, buy a home, maintain a home, business, or whatever. We can do that. So if they need that extra protection, we can add that in, so that the inheritance that they're getting is a benefit, not something that they're going to blow through rather quickly. Then think about special needs or means tested, special needs children. If that's the case, we need to set up a trust separate for them. That trust is going to be designed to keep the principal intact, with a trustee that has the ability to act more like mom and dad would. That, if we can get, if there's governmental benefits or other benefits, from charity that will help these kids, these special needs kids, use that money first. Use those programs to their advantage. But if you need to, as the trustee, you can spend every dime in that trust if it's in that special needs child's best interest. The other things that I look at is protecting, from creditors or divorce, addiction problems. All of those are special situations that your estate plan, a lot of times we think the estate plan ends when you pass, and then we just divide it up. But remember, we can have trust, depending on your state, that can last for the lifetime of your, kids and grandkids, or I can set up trusts that can last forever. Whatever it needs to take care of you and your family and whoever your beneficiaries are, let's make sure that we just set it up in a way that protects them now and as long as we have to. The other one that I look at that's a really common is blended families, from second marriages. I meet with clients that it's his kids, her kids, and our kids. How do we want to address that? How do we want to make sure that it flows the way that you want to? And a lot of times it's, we don't know which spouse is going to pass away first. So we have to plan for, if he passes away first, what does that look like? If she passes away first, what does that look like? On the second passing, what does that look like? So we have to think and really take it and make sure that we're addressing his, hers, and our kids the right way. And we're protecting our spouses, in that after the first spouse passes, how does that look to making sure everybody's taken care of? We're not locking up money and assets away at the wrong time, but there again, think it through. And the more open we are about those issues in the planning process, the better result we're going to get. So, at the bottom line, setting up the trust the right way is going to protect our beneficiaries, making sure that what you want happens. So as you think through the implementation process, number one, any of your estate planning documents, after they're drafted, we want to make sure they have to be signed properly. So with a will in every state, with your will, we have to have it signed by you, so dated and signed, witnessed by two unrelated individuals and notarized. With the trust, we typically just need to have that, signed and notarized, powers of attorney the same way. And so we just want to make sure, sign it properly, and it depends on every state you're in. Move the assets in that are supposed to go to the trust. Update any forms and titles. So any beneficiary designations, we want to make sure that they're all set up and coordinated with your estate plan. I've been the bearer of bad news where I've had to tell people, yes, I understand what your mom or dad wanted to do, but the beneficiary designation on their IRAs is wrong. It's probably not what they wanted, but once you have a beneficiary designation, that's a legal binding contract. And once somebody passes, we're bound by the contract. We're bound by the beneficiary designation. We don't get to cry about it. We can't take it to court. It is what it is. So think things like life insurance, retirement accounts, bank accounts. If they have beneficiary designations, we always want to make sure they're up to date and matching in with the rest of the estate plan. Organize all of your documents so that we have originals and any copies. Always remember who you gave copies to. The last thing we want to have is, your oldest, child has one set of documents, your youngest child has another set of documents, and you may have superseded those with the third set of documents. So we always want to know where the originals are and who has a copy, so we always stay up to date and everybody's on the same page. This last one, number 5, tell the key people where things are. The last thing we want to do is go looking. I've had situations where clients have come to me and they said, we know there's more bank accounts out there. I have to shrug my shoulders and say, I don't know where to look. Or, there's been stock accounts that have been lost, stock certificates nobody knows where to find. Yes, you may know they exist, but if we can't find them, we can't do anything with them. But tell the key people where to look and where everything is. The more organized you are, the better the transition will be from you when you pass or become legally incapacitated and we have to use the powers of attorney. Review and revise. That's one thing that I keep harping on with my clients. We want to make sure that your documents are always up to date. Think about, from my side, I want to have regular reviews. From your side, I want to be updated from major life events, marriage and divorce, births, moving to another state, selling at large asset sales, large asset purchases, healthcare concerns. All of these things are important for us to make sure they're updated, because if we don't update your documents, for these big events, something's going to get missed. And I can tell you, I see this quite a bit, is we have, you may have set up your documents and somebody, passes away. How do you want that to go? I'm working with a client right now that she has a major health concern and probably will pass before her mother's estate is distributed. Well, she has certain places she wants it to go. Well, now we have to go back into mom's estate planning documents to see how she set it up in order to be able to take care of that, because there again, she's going to probably pass away before things are distributed out. So we have to coordinate that. So it's just making sure we're always up to date. One of the things to remember, and it's sitting here on this important reminder, do not handwrite changes onto your will, trust, or powers of attorney. So if you have a will and you go in and say, oh, I didn't want this provision, I wanted something else, you scratch that out and handwrite in something different. Not only did you make a big mistake, you made a huge mistake, because that will, you didn't just delete that one provision. Either A, it's not valid, or B, you invalidated the whole document. So it's creating a hole in your planning. So anytime you want to update it, the same process that we went through to sign and do everything the first time, we've got to repeat that. So if you want to update your will, it's fairly simple. All we do is what's called a codicil. It means an amendment. And we just say, delete this provision, add this provision in, sign it the same way. So if it's a will, we're going to date it. You're going to sign it. You're going to have two unrelated witnesses, and it's going to be notarized. If it's a trust amendment, there again, we just say delete this section, put this new section in, so that we update that, sign it, notarize it. It's easy to keep things updated. Don't hold back thinking, well, I don't want to go see the attorney. I don't want to pay for it. We want to make sure it meets your wishes, and to do that, we've got to keep it updated. When you look at the advanced topics, the advanced tools, think about these: the foundational document, your wills and trusts and powers of attorney. All of those are the foundation. Everything else is going to, be brought in to take care of additional situations. They're not, I guess advanced planning is a lot of times is not the right wording. It's an additional planning. We've got to do more to make sure your goals and objectives are met. So if you think about it, charitable planning, a lot of times you may be giving, things on a regular basis to the church, to community events, whatever. When we look at you doing big gifts, we might do, charitable remainder trusts, because we can set up a gift to charity that'll happen when you pass, but you get to use that income while you're alive, or a charitable lead trust where we give money to your charity now. And we do that, say, for 5, 10, 20 years, whatever it is. And at the end of the trust term, that comes back to you to be able to live on or pass on to your family. Those are usually done in a way, or for reasons of, one, we want to give bigger chunks, or we want to avoid some income tax problems. You're selling a business, you're selling a large investment portfolio, whatever it is. If you have those big income events, charitable planning is a great way to reduce your income taxes while we're giving more to charity and still benefiting you and the family. Other ways we can give are donor advised funds or direct gifts to charity. We want to be looking at those if they make sense. We want to just make sure it's done the best way possible. And if you have IRAs that you don't need, we can do the qualified charitable distribution, where you can give a large amount to charity. Instead of taking your required minimum distributions, you can give that direct to charity. You don't get an additional charitable deduction on your tax return, but you don't record that as income. So that could be a great way to move things along. I look at this protective planning. There again, a lot of times in the additional planning, we need to have irrevocable trust set up, because we may have an asset protection issue we want to avoid from our creditors. We want to pass things on to, kids a little bit different than the normal revocable trust, or we want to set up special need planning now. And I have a lot of clients that I work with in the special needs areas where they want to start building that trust up now, getting assets in so that they can see and make sure it works for their kids before they pass away and have to turn it over to somebody else. So just think about that. If we need to do extra, let's talk through what that extra looks like. And if we need to do it, great. If we don't need to do it, that's great too. It's just there again, what can we do to help you achieve your goals? From the income and care planning, I look at that as, if you have life insurance or annuities already, let's do a review to make sure they're doing what they're supposed to do. One of the biggest things that I see happening with a lot of my clients, and this isn't, it's just because we have an aging population, is long-term care. Long-term care, when we're looking at long-term care, it's more of working inside the income problem versus anything else. When I see a couple is in their retirement years and one of them needs long-term care, and when long-term care happens, there again, the family might be providing help. We might have to get, other help other places. What I find is the problem is that bill is going to get paid. How can we pay those bills more efficiently and setting aside money now in a long-term care policy, setting aside money in a life insurance policy with long-term care benefits? There's lots of ways to solve this problem, but ignoring the problem is not the right answer. It's addressing it and making sure it's addressed the way that you want. So there's solutions out there. And we just want to make sure that we plan your estate and your income planning so that as you go into your retirement years, that we know that we have retirement income, we have the long-term care addressed, and then we have what if planning, and we do it in the most tax efficient way possible. So it's all of these things are just there again, helping to make sure that you get to the right place the way that you want. So here from, to wrap things up on this part of it, is just looking at, what's a practical starting place. So making sure that you gather, if you have current, estate planning documents, trust wills, powers of attorney, healthcare directives, get all of that together, because we may not be starting over, but we may be needing to do that review and refresh, bringing things up to date. Make an inventory of your assets and how they are titled. How they are titled is important. Are they joint assets? Are they separate property assets? Are they community property assets? There again, we just want to know how they are titled so we can address and make sure they get titled to the right titling and beneficiary designations that we need to get. Make sure your beneficiary forms have both a primary and contingent on there. A lot of the times I see the primary, beneficiary may have predeceased. Well, now what? It's going to either go to according to the contingent beneficiary designation, or it falls back into your estate plan, which may or may not be the right answer. Decide who's going to be in the fiduciary roles: trustees, executors, agents under the power of attorney. Who do you want to take over when you can't? So think about that. It's not a glory title. It's not, hey, here's who thinks they should have that position. It's you deciding who the right people are and list them out in order. And then finally, write down where your original documents are. Don't let people run around and guess. There are court cases out there where people put their will in their safety deposit box at the bank. Well, nobody has the authority to open that safety deposit box until after probate happens. Well, we can't probate a will that's in a safety deposit box, and there's court cases where everybody agreed, yes, the will's in the safety deposit box, but nobody can access that safety deposit box. So there again, just put it in the right spot for you. Make sure it's all of your documents are together, and then make sure the right people know where that's at. So when you go to your attorney, make sure you're bringing everything with you, and be ready to explain, here are the things that I would like to have happen. And now you can get this drafted. Remember, drafting the documents is step one. Getting them signed properly, step two. Get your beneficiary designations set up the right way, and then make sure whoever's in charge, one, they've agreed to do their job, and two, they know where to find your documents so that you're ready to move forward. So I appreciate everybody going through all this, and let's move forward to some question and answer.
Rick, that was just excellent. We've got a lot of good questions, and the practical nature of everything you've said is just so clear, and I think will be incredibly helpful to our audience here. First up, do you have a suggestion for an estate lawyer in Illinois, preferably not downtown Chicago? I live in Marengo, Illinois, and I have learned a lot from your course. Thank you.
I don't have a name off the top of my head right now, but if you will email me, I will give you some suggestions on who I'd recommend.
Perfect. Great answer. Next up, assigning my power of attorney as immediately upon signing versus springing becoming effective upon disability would be more flexible and wouldn't require verification by physicians for the agent to act. Is there a concern or danger with appointing someone immediately after signing the document? How would any successor agent then get assigned?
Okay, so here's the problem. This goes back to agency law, basic agency law. If you give an agent power to act now, you're giving them the power to do anything that you can do. So let's think of what could go wrong. Let's say you've got a bank account with all of your life savings in that bank account, and you gave your agent the ability to go act immediately. Your agent can go drain your bank account, and legally they did nothing wrong. Now, we can discuss morally, did they do something wrong? But legally, you gave them the ability to go do what you can do, which is spend all your money, sell your assets. And so there again, you're picking people you already trust, but there again, are you at the point you want to give up that control? And I have some clients that would say, absolutely don't have a problem with that. I also talk to a lot of parents. They don't want to give their kids control of all their assets now, but they're okay with it when I become mentally incapacitated. So the downside of that is with that springing power is typically two doctors have to sign off, or two medical professionals, that you do no longer have the mental capacity to act on your own. But I can also say what I like to see with those documents is an additional document that says you can sign it anytime you want, that says I am giving up my right now. I'm basically declaring myself legally incapacitated, and I want my agent to start working for me now. So it really comes down to a trust issue and what you feel comfortable. Do you want to give up that power or give them power now, or do you want to wait? And I would say, personally, with most of the clients I've worked with over time, they're not ready to give up control. They trust their kids or trust whoever they've named, but it's still mom and dad, and they want to control it as long as it makes sense for them. But I do have clients that get to that point, they know they're slipping, and they're ready to sign off saying, yes, it's time. I need the extra help. And that's nice to have that document. Now you don't have to go to a doctor. You don't have to go back to the attorney. Just sign it, notarize it, good to go.
That's great. Your experience, Rick. I love your stories. We've talked about this many times. Next question. Can you discuss the benefits and disadvantages of choosing successor versus joint power of attorney agents, and of successor versus joint executors on a trust? Would joint appointments give people more flexibility, or will it cause problems? I'm considering appointing my two children jointly and would want them to be able to act independently, but to consult and collaborate with each other when feasible.
I come across that question a lot. And I look at it, number one, if you're naming, two kids, joint trustees, joint executors, whatever role they're in, number one, do they get along? And I've been in situations where mom and dad named their two kids, and the two kids don't get along. And so we're stuck because nobody can make a decision or won't make a decision.
Mm-hmm.
Always look at it. And if you've ever talked to an executor or a successor trustee, it's not a glory position. It takes work. So I always say put the right person or people in place. If they get along great, if they work together, then you're going to have to give them direction. And it goes both two ways. You can say, especially if I've got two trustees, that they have to agree on every decision, or you can give them the power to act independently. And you just have to decide what is this for convenience? Is it the right thing? I deal with clients and I've had some where, the daughter lives next to mom and dad. The son is clear on the other side of the country. And so from a convenience standpoint, daughter is probably in a position to make more of those immediate decisions, but give them direction that you would like them to counsel with each other and to make the decisions jointly if possible. So it becomes a logistical issue if you've got more than one, if you have joint trustees, co-trustees, it's not impossible. It's just, you have to look at logistics and are they the kind of people that will work together?
This is not a question that was given by the audience, but just very briefly, you said it's a lot of work, and I'm well aware that it's a lot of work. How does the fee structure work for a trustee so that they feel like, wow, I'm really going to be putting in a lot of time here and I'm going to be compensated for it? How does the fee structure work for a trustee? How to choose that?
So let's talk if you go to a professional trustee. Professional trustees will typically charge based on either time or value of the assets, some percentage of assets. So that's the high point. Then I have a lot of family members that will do it, and they just do it out of obligation to mom and dad or whatever, and so they're not going to take any fees. It's like I'm doing what I needed to do to help mom or dad, and so I'll do this. If it means time away to take care of, and I'll split everything equally with my siblings. So I think the answer is somewhere in the middle, where if I typically would say at least compensate them for their time and expenses. So it's one, if they're taking time away from work, if they're spending time and money of their own, to make sure things are taken care of, at least compensate them for the time involved plus the expenses that they're incurring. I think that's fair. I don't think anybody's going to argue, and there's no real answer to what's a reasonable fee. And I will have some that say, for my daughter taking care of this, pay her $25,000 as a trustee fee. And that could be exorbitant. It could be way low depending on the situation. But you have to look at that situation and just see, who are you naming? And it's different, I think, if it's kids versus, you've named a friend or a sibling or a neighbor or whatever. If they're not related, typically you're going to have to add some kind of reasonable fee in there.
Great. Thank you. Next up, if I have successor agents for power of attorney, financial or medical, and my first choice is not available at the start, can this person become my agent if the second choice is no longer available? Can they switch back and forth? Is it possible or necessary to put language to permit this? Put language in to permit this?
Typically, you would have to put language in to permit that. The typical language would say, let's just say I nominate John as my agent under my power of attorney. And if John can't do it, then it goes to Amy. Whatever, if that's the order I put it in. Now, if John says, hey, I can't do it, we put a line through John's name, and Amy, you're next up. Do you accept the act or not? Typically, it's once you're X'd out, you can't come back in. And so, but you can add language in there that says, if John isn't able, willing, or to do it, and Amy steps up and does it, and if Amy resigns or is unable to do it, then John has the ability to step back in, or it goes down the list. So always think through that. There's no right or wrong. I always look at, is it the right people? And there again, circumstances, let's say you named one of your oldest, child, and timing's not right. They're across the country, they're deployed in the military, whatever it is, I don't know. But they can't do it at that time. They still may be the right person. So add that, you'd have to add that language, or have the attorneys add that language back in to make it work.
Great. Next question. These are good questions. Should I give my power of attorney any extraordinary powers to give gifts, create trusts, amend or terminate trusts, to change beneficiary designations? I believe my attorney suggests this to protect my assets from long-term care costs, but I feel a bit concerned about giving my agent so much authority.
I like a broad power of attorney, but I also like it to be very specific. And I've seen powers of attorney that allow, you to set up, trust, change bank accounts, buy and sell real estate, on and on and on, make charitable gifts, make gifts to children, gifts to grandkids. All of that, if you're, the more direction you add in there, I do like the very specifics if it matters to you. But there again, if it's something you're not comfortable with, definitely make sure that's taken out. I go back to this. Don't be satisfied with just a boilerplate document. And I see this way too much, whether it's the trust, wills, or powers of attorney, that it's a take it or leave it. You came in, you didn't, the attorneys are just running you through a mill, and you end up with boilerplate documents, nothing that says, here's what Rick really wanted. Mm-hmm. And think about this. If there's something in there as you review the documents that you're not comfortable with, make sure it's changed before you sign it.
Great answer. Next up, for my digital assets, emails, online accounts, what should I be aware of when giving my agent access for power of attorney or to my executor?
Two things there. One, make sure they have access to that it's written down. My little sister passed, a couple of years ago, and we had to go back through it. Did we have access to all of her bank accounts? Did we have access to, her email accounts? Did we, she did a lot of things online, she's in that generation where everything's paid online. We had to make sure we had access to every single one of those accounts. Mm-hmm. And before she had passed, we had gone through it with her and made sure, is there anything that you have? And lo and behold, guess what? She didn't tell us about one of them. And it took us 6 months to get access to that account. And it was just proving, hey, we're the ones that are, helping the estate, helping our, my nieces and nephews. And it's just an oversight. But there again, if you remember, if you're giving your agent under a power of attorney, ability to act now and they have access to all that, they're going to see everything. So just make
Right.
sure, A, it's the right people, B, they have the access when you're ready. But
Yeah.
make sure, there again, write everything down because we live in a digital world. I mean, there's a, it's well known out there that a guy that had invested in crypto and it's all locked up in a computer somewhere in a trash bin somewhere in Canada. And it's billions of dollars, but nobody can access it because it was a digital account and it's gone. So if we can't find it, if you don't organize it in today's digital world, it's hard to recreate it.
So get people you trust and write it down. Wow.
Yep.
Yep. Here's a good question. How long will the replays be available to watch? I'm not sure either one of us can answer, but we'll keep them up for a long time. Eddie, that's we'll get back to you on that. Everyone will be informed on that. It's a great question. But they will be available to those who thank you for paying for these webinars. Those of you that are on the list. So it's great. So glad you're here. Next up, is Illinois a state where you would not want to use probate, not want to have to use probate?
Illinois is one of those that I would say avoid probate if you can. I mean, that's one of those states that's a little bit more bureaucratic. And if you can avoid probate in there, definitely do it.
Mm-hmm. Yes. Here's a good one. This is a little bit longer than usual. We have 2 questions. If anybody has any questions, now's your time. We're coming up to the top of the hour. Conversation with a local attorney says that we don't have an estate large enough to worry about needing a trust. However, our one child is repeatedly asking to have a trust set up to have the house put into. He thinks having it already in the trust will allow him more time to figure out what to do with the property, as opposed to having the property go directly to him upon our passing. What is the best thing to do here? Also, I'm concerned that if we sign a transfer of deed upon death, or a TODD, that the increased value of the house since we bought it will cause him to be responsible for a large tax bill. Would this be an accurate understanding of the potential situation? If so, would creating a trust keep that from happening? If a trust wouldn't prevent that potential tax liability, can you suggest a method that will?
I'll take the last part of that first. So when you pass, so with the federal estate tax laws, and I'll address federal and then come back with the state tax as well. With federal tax, because we have an estate tax, at death, all of your assets, whatever assets you own, so if it's remember, if it's in a revocable living trust, that's treated as your asset for your estate for estate tax purposes. What happens is when you pass, all of your assets step up the basis to fair market value. So anytime you sell an asset, its sell price minus your tax basis equals the gain, and that's what you pay capital gains or ordinary income on. So if all of your assets at your death, so if you own that home, it's either in your name or it's in your estate through your trust. When you pass, the value of that basis, whatever you bought it for, we ignore. The basis is stepped up to fair market value. Your son can sell that the next day and will not pay any capital gains tax on that sale, period. Now, with go back to the rest of that. It's one of those where if you have a will and you own real estate, you are going to end up in probate, period. There's no signing a deed ahead of time. There's no transfer on death designation for a real piece of real estate. So at death, you own that real estate, you own that house. And the way it ends up going to your son is he's got to go through probate. There again, we've talked about on this. Some states probate's not onerous. It's a little bit time consuming. It costs a little bit of money, but there again, if you're in the right state, not a problem. If you're in a California and New York, definitely don't do it. Put it in trust. I like, if you have real estate, most of the time I like having it in trust. Let's get it into the trust, get the trust set up, get it in, transfer that, deed that property to the trust. Then when you pass, your son becomes the successor trustee. And now he's got control of what he does with that. Does he sell it? Does he transfer it into his name? Whatever permission you've given to him into the trust document, now he can do that. But we don't have a court looking over his shoulder. We don't have public notice that, you've passed away. There is a probate. Creditors come, line up if you can or want to. There again, it just makes it very, very easy to transfer it, but you've got to separate it out. Transferring the asset is one process we have to go through. The tax is a separate secondary process. We just have to make sure both are addressed, but you will get a step up in basis. Now, the federal estate tax exemption as of today is $15 million per person. So if it's husband and wife, we've got a $30 million estate before we have an estate tax problem. That's indexed for inflation. I was at a conference today, we were talking about it. Estate tax can change. It depends on who ends up in control in Washington. Now, you have to be careful depending on the state you are in. Some states have already set up their own estate tax, which is typically at a much lower amount. I've worked in Oregon. Oregon has an estate tax that starts at $1 million. Washington has an estate tax that starts at about $2.2 million. Different states, there's no rhyme or reason who does it, but I can tell you, I just saw this in New York. There's potential in New York. They're looking at an estate tax with an exemption as potentially as low as $750,000 as the exemption amount. So it just depends. You've got to look at the federal side and the state side to just make sure you don't have an estate tax problem at either level.
Golly. This question ties right back to what you just said. Estate limit. Do assets I own at death that my will or trust gives to charity count towards the estate limit, or are they exempt?
So when you file the estate, if you think about the estate tax return, we go in and we find all of your assets. Then we add them, it's added up. That's your tentative estate. Then we get a deduction for anything that's going to charity. So we count it and we take it right back out. And then we get down to the real estate number and then count the exemption against that amount. So the short answer is that will not be counted against your exemption.
Great. Okay. Well, here's the last question. My beneficiaries, one of whom will be my successor trustee and the other being the backup, will have the opportunity to request any specific items they may wish for my estate. Beyond that, there will be an estate sale. Can that be overseen by the successor trustee and the sale proceeds divided evenly between the two beneficiaries?
Yes. I mean, make sure it's clear, because if a couple things in there, if they have the ability to ask for specific items from the estate, now you want to have what happens if they ask for the same thing. Now I can tell you, I grew up in Idaho, so I grew up hunting with my dad. My dad has two guns. My two brothers and I, we all grew up hunting with dad using the same guns. There's 3 boys and 2 guns. And Luckily I'm the biggest of the three, so maybe if it comes to a wrestling match, I can hold my own. But you think about that. If you've got two beneficiaries,
Mhm.
what happens if they want the same item? And
Sure.
think through that. Maybe there's a raffle, a pecking order. They get to go through and choose them. In order, one then the other. Especially if they're heirloom items. Those are the things that matter the most.
Sure.
Mom's jewelry. Those types of things. So I just make sure it's orderly, and you can have one person handle the allocation of who gets what, and then somebody else divides up the final. However you want that. If it makes sense to you, and that's how you want it, then that can be drafted in there. It's your, really think about this. It's your estate plan. What do you want to have happen? And make sure as
Right.
you explain it to the attorneys, this is what I want. This is important to me. A lot of times, let's be honest, a lot of things that happen in the estate, they're just, they need to be done for a legal reason or a tax reason or accounting reason. We really don't care. There's items that don't personally matter to us. There are items that very much matter to us. Let's make sure the things that matter to us are done. The rest is just administrative. And if you got multiple kids, what's important to them. I mean, there's certain things that are important to me with my parents that my siblings don't care about. It wasn't things that mattered to
Mhm.
them, but it's important to me. And some of those things have already walked out of the house, so I've solved the problem. But there again, make sure what you want to have happen is on paper. If it's not on paper, it's not going to happen.
Excellent. Get people you trust and write it down. I love it.
Yep.
Yeah. Well, Rick, thank you. Thank you for another informative session. And thanks to all for your great questions. I think this has been so good today. We hope this Get It Done webinar series has served its purpose and that you'll consider Ardenwood in your plans. What a difference you can make. And finally, a quick reminder about our Ardenwood annual meeting. It'll be taking place on Sunday, May 3rd. That's again the first Sunday in May at 2 p.m. Pacific time. Our speaker this year is Bruce Jeffrey, most recently the executive director of the Principal Foundation. Bruce's talk is entitled The Third Great Commandment, that you love one another. Isn't that great? You'll receive an email invitation soon, so please keep an eye out for it. It's really beautiful. Rick, thanks again, and to all, goodbye for now.
Thank you.